quick announcement on the Wirewheel side. We're very excited to announce that we've just launched our new universal preference and consent platform. It's now generally available. And our new platform is really addressing those critical needs, specifically around some of the new laws in the United States and globally. And we're really, looking forward to working with companies, helping really solve for some of the new requirements around the country, especially around the Sephora enforcement decision in California.
Thanks so much for everybody who's joining today at Spokes. We have a fantastic second session today. We opened the day with a session on age-appropriate design, and now we're coming into a huge topic that so many of us on the privacy front and on the data protection front and on the marketing front are really in a position to tackle. And that is, how is California actually enforcing the CCPA? And how will they start perhaps enforcing under CPRA, which comes into effect obviously here in a few weeks? We have two fantastic panelists here today. I'd like to welcome Donna Fraser from BBB National Programs. Donna is a frequent leader and a participant here at Spokes, and many of you just saw Donna on our panel on age-appropriate design. Donna, do you mind introducing yourself briefly and talk about the work of BBB National Programs here in this area?
Sure. So thank you so much for having me again. At BBB National Programs, I oversee all of our privacy initiative programs, which include everything from, as we previously talked about in the last panel, our CARE, our Children's Advertising Review Unit, up to our EU Privacy Shield, or what the new framework is going to be, CBPRs, cross-border privacy rules. So we're doing teenage privacy, we're doing digital health. Wherever there's data and privacy, BBB National Program is there to help companies identify the issues. Obviously, with what's happening in the States, and particularly California, we're working with companies really on the ground up to build their compliance efforts to ensure that not only are they just complying with the laws, right, but they're actually hitting higher standards, best practices. Those are challenging right now, right? I think right now people are just focused on just complying with the rule and the regs, which we know is extremely challenging, and Jiwan will get into the specifics of that. The three of us have talked about how challenging this law is to comply with, and that probably is likely that no one company will ever be fully compliant. So working with companies to figure out what are the top 3 or 5 risks that they need to identify for themselves to really at least ensure that they won't get the knock on the door. So we're working closely with companies to figure all of that out.
Well, terrific. And we're proud to be a partner of BBB National Programs, Donna. And thank you for that introduction and for all you do, honestly, in this community. So with that, I'll introduce Jiwan Serrato, who is partner and co-chair of the Digital Transformation and Data Economy Practice. Jiwan, if you don't mind giving a moment or so about yourself and your practice. And obviously, law firms around the country are now receiving these enforcement letters from California. And you, Jiwan, are in the center of one of the bigger ones, but I'll let you talk about that. So over to you.
Thank you, Justin. Thank you so much for having me on this panel, and happy to be presenting with Donna, and really appreciate opportunity to speak with your network here. My name is Jiwan Serrato. I'm partner in the San Francisco office at Baker Hostetler, and I'm one of the co-chairs for the digital transformation and data economy team. I largely help companies solve privacy and cybersecurity issues, but I'm really focused on what we're calling digital transformation. I think the companies are often calling us when they are about to launch into a new market. So for example, if California is a big revenue generator, if US is a big generator and you're a global company, if you have a specific market and that market market is very active in privacy regulation and also in enforcement, as we're going to talk about in California. I think that's one way that the companies call us for advice. Second way is when companies are going into business opportunities that they haven't done before. So regulated entities like financial services and healthcare that are going into kind of consumer-facing retail space or tech space. So fintech, health tech, because the regulations in the consumer space is different than in the previously regulated spaces, or vice versa for tech that are interested in going into the more previously regulated spaces like healthcare and financial services. Before joining Baker Hostetler, I served as a head of privacy and chief privacy officer for 2 public companies, including Relics Group, which is a global data broker risk analytics company, and Fannie Mae.
Terrific. Well, we have a lot to talk about. I think if you're working with any consumer-facing brand like we do, and they've talked to their lawyer and they've read about the decisions and some of the enforcement actions that have been coming out of California, the subject of the recent enforcement actions is top of list. What does it mean? What do we do? How do we action it? What do we have to do on our websites? Jawan, I know you're handling the Sephora matter, among others, as it's referred to in shorthand. Do you mind talking a little bit about it from your perspective, and maybe some of the main lessons you would take from what happened in that case?
Sure, happy to. First thing that I like to share is that this is just one of many investigations that we handled on behalf of clients. This is the first publicly announced settlement. And when you have a settlement with the California AG, there are no confidential settlements. So all of the other investigations that we have handled in the past and are ongoing, they are going to be confidential until the settlement becomes final. A lot of the investigations were resolved, and you don't get a letter saying you're good to go. You basically, the California AG stops asking questions. That's how you know that the investigations has been resolved and there will be no public settlement. So just wanted to kind of clarify in terms of the process and why you might not be hearing about all the investigations that are happening behind the scenes. The enforcement for the CCPA began in July 2020. So we have in fact been working with several companies for a year or two. Some of the more lengthy, significant investigations were a year or longer, which was the case for Sephora. So in terms of the timeline, in June of last year, 2021, is when Sephora received the first notice of violation letters, and investigation continued until it became final and was filed as a complaint and a draft resolution in terms of the settlement in the San Francisco courts on August 24th. Everything that I mentioned, I have to provide a caveat for today. We are not going to be speaking about specific Sephora negotiations because that's confidential to the client, but I will be drawing from the experience having defended several companies, and I think that is going to be helpful because we have really kind of seen several industries receive letters like this, and the responses from the clients have been quite bespoke. Even in the same industry, hospitality and retail and financial services, depending on the maturity of the program and the certain positions that each of the clients took, we took different positions and we tried different responses. So I think it is helpful to draw from the experiences of the several investigations and be able to tell you, this is what we learned. If you were to say, what are the 2 key takeaways from the Sephora settlement? I think one is that this is definitely not the only issue that we worked with. Most of the times when you get a notice of violation, it starts with several issues. So we have a number of enforcement letters that we received called notice of violation that are single issue, very rare. There were a number of single issue letters that went out for the notice of financial incentive in January of this year, and a number of single issue letters went out focused on the GPC following the Sephora settlement. All of the other investigations will be multiple issues. It could be right to access, right to delete, right to opt out, right of non-discrimination, notice of financial incentive, and so on. Now, what do we learn from the Sephora, which is a second point, is that they really wanted to highlight the do not sell opt-out. So if you take away anything, it'll be one, there are many investigations going on and many different issues being reviewed by the California AG in terms of compliance. The priority, I believe, that they wanted to move forward with publicly announcing was do not sell, opt-out right, and GPC.
That's an important set of items. And I think many folks just reading, so just so we're all on the same page, because of course there's so many lawyers, and I see the attendee list, a ton of friends who we know very, very well from around the industry already. Many of us read the press release that went with the enforcement decision, and it highlighted a number of different things that we from the Wire Wheel side, and obviously Donna, you and I have talked about this, and Jawan, you and I have spoken about this as well. There were 3 exchanges that I saw, or that we saw in the press releases that caught so many of our eyes. So I'll highlight them, and I think they've led to, the requirements discussions that we've been talking about. The first is this one. If companies make consumer personal information available to third parties and receive a benefit from the arrangement, such as in the form of ads targeting specific consumers, they're deemed to be selling consumer data and information under the law. Now, this is an interesting and important, in our view, expansion of how people have thought about the sale of data under CCPA. I think many of us saw that the sale of data and the coverage under CPRA was going to be broadened. So we knew a lot of these things were coming. This is not a shock to the industry, but to start seeing mentions of the sharing of data for the purpose of improving the performance of an ad, something that happens every day all across the country, using pixels, tags, scripts, normal digital marketing methods, that caught a lot of people's eyes. So that's one critical passage we saw. The second one was both the trade of personal information for analytics and the trade of personal information for an advertising option constituted sales under CPRA. So now you start seeing it moving from just, per ad performance to measurement and normal digital marketing techniques like frequency capping and others. So on one side, you see the requirements, which is you start seeing an interpretation of California CCPA in a way that says, if you're using consumer data to sort of improve the performance of an ad, measure the performance of an ad, use normal techniques like frequency capping, that is a sale, at least as according to the press release. And then you get to what they're asking for, at least under the press release, which is you must give a manual way to opt out. You must give a way that automated marketing is in fact wrapped or prevented in the case of an opt-out. And you have to be able to put up something that collects a touchless opt-out like the global privacy control. So I'm going to come to this in a moment, but those were some of the main concepts that we took, at least from the press release. I don't want you to have to speak, obviously, from your perspective about Sephora specifically, but across the enforcement actions, when you abstract the kind of things that California is asking for, Jawan, are you seeing that as the trend? Is that an accurate kind of representation of what California seems to be asking for?
That's absolutely right. And in terms of kind of process, giving you some insight into how the California AG enforcements work, what I would ask for those of you that are reading this closely is to scroll down from the press release. So you can just Google AG Bonta, California AG, Sephora, the enforcement action press release comes up. Scroll down, there are 2 documents at the bottom of that press release. Read those. The press release is helpful because the press release kind of gives a flavor of the priorities and the way that the California AG is thinking about this. But in terms of the legal requirements and what you must do, what I would point to is the actual settlement. So it is the judgment that is the legal document that Sephora has agreed to. It's called the proposed final judgment and permanent injunction, which became final. So we drafted that together, negotiated that significantly with the California AG. That's a document that the parties agreed to. So if you're looking at where Sephora ended up, the draft judgment is where you should go. There's a second copy that's the complaint. So one thing to note, which might be surprising to some of you, because this is not the way that it's done, for example, in FTC or some of the other state AG investigations, is that California AG does not share a copy of the complaint nor the copy of the press release normally with the other party. So we were just as surprised, and we received a copy of the complaint and saw the press release on the same day that it became public on August 24th. So if you're looking for what the parties agreed to and kind of the legal requirement, it's the draft judgment. Again, what you should take out from this is that there is going to be what the AG is signaling through this settlement is that there is going to be a healthy dose of priority and focus in this area. So advertising, targeted advertising, use of ad tech, online tracking technologies is a term that was defined as part of the settlement. And we really worked hard to, I was representing Sephora, but, we represented several other companies on this issue. And so we wanted to make sure that what we were hearing from the California AG were shared to the industry. So this is the term that the California AG put forward: sales using online tracking technology, defined in the judgment. If you take a look at it, it's quite technical. We're talking about pixels, we're talking about cookies. You're right, it goes into measurement issues, it goes into analytics cookies. And so I think some of the questions that we have been getting a lot from the clients is, how important is this? I would say a lot of the privacy officers around the country and globally in the past may not have focused so much of their investment in terms of privacy improvements in the area of targeted advertising. You may have never spoken with the head of marketing. You might not really have your hands on all of the ad tech self-regulatory controls for organizations like BBB and IAB to put forward. This might not have been the area that you focused on in the past. What this is is a public, I want to say, an announcement by the California AG. And if you look at the other states too, I want to say all of the other states are following suit. So you have 4 other states that are following suit with definition of targeted advertising, slightly different versions of definition of sales. So what we are really kind of hearing across the country is that, again, retail and tech, or hospitality. So if you're a consumer-facing company, and you have direct-to-consumer advertising, targeted advertising on social media, on ad tech platforms, and you are driving some type of a benefit from these targeted advertising tools, that this is going to be characterized as a sale under the law in CCPA, and the law went, into effect in 2020. So the enforcement of allowing the consumers to opt out from this type of targeted advertising, I think it's going to be bigger and bigger issue moving forward.
That's a phenomenal transition to you, Donna. So the BBB works with companies all over the country, and you also are constantly thinking of the consumer and the data subject and what's meaningful for people around the country. There are a number of different subjects that just came up that Juwan just covered, but if you don't mind, I'll tee up a few. From the consumer perspective, it's really, honestly, confusing how you can exercise your choices, in my view. And you can see in the enforcement press release around the Sephora matter, you can see the Attorney General starting to push the burden of making it easier to the brands and advertisers, that it's really their problem. It's not consumers that should be chasing it down. You can see that in how they're dealing with automated marketing and the need that you have to sort of wrap that in some way technically. You can see it in the way they talk about an easy way to opt out manually. And you can see it in the way they're really requiring a touchless option like the global privacy control. These are all issues BBB's been championing for a long time. What was your reaction, if I may, to, to these kinds of things in the Sephora decision? And what are you seeing coming up as challenges from the company side, from the industry side, if they're trying to actually do the right thing, which many of our companies are?
So, us, the three of us, we've talked about this with regards to what consumers actually know, right? I mean, I find it fascinating that we have these numerous consumer protection laws, and I'm not convinced that consumers even know what they're being protected from. So if they don't know what's actually happening, what is supposed to be happening when they visit a website, when they go to an app, when all this sort of stuff, when they're faced with choices, consent, opt-in, opt-out. We know that when we saw cookie banners on sites, accept all, or don't accept any, or customize your cookies. All we know is that consumers just want to get to the content that they're there to access. They just want to get to it. And we know that companies are always challenged with, the more clicks it takes to get from, point A to point B, the likelihood is that you will lose a consumer. We know that in talking to businesses. I think we all know that. So I think it's extremely challenging to just understand what consumers actually understand about this and how they're presented with their choices. The fact that the burden is on companies to make this easier is another challenge, because I think there's just trying to figure out how do we do this in such a way that, again, reduces the friction in the user experience, because that's what this is all about, right? Is trying to get the user experience to be the most robust and engaging experience without them feeling as though their data is being compromised. How do you communicate all of this in 1 to 2 clicks, right? In one notice? Just you and I have talked about, we've been working on this for what feels like forever, is how do you do consumer choice and consent in a robust way that helps consumers understand exactly what's in front of them, gets them to where they need to be, and the companies have done their due diligence, that they've been able to just, consider how to demonstrate this approach in such a way that reduces their risks, right? Because under this law, they have to classify their vendors, prioritize risk, make sure they have all the right contracts in place with all of their vendors. And when we talk about all of their vendors, for so many companies, that can be hundreds of vendors, right, that they're dealing with. They have to create an audit process. I mean, I think what we saw with the Sephora case in general is that if this case doesn't allow internal privacy folks at companies and organizations to be able to have the conversation with the higher ups about, this is no longer a nice to have, this is a need to have. We need to make an investment in privacy compliance. If this case doesn't help you have that conversation, I don't know what will. I really don't know what will get you there, because how to demonstrate a proactive approach for privacy to regulators is an investment that companies must make. They must. There's no longer a choice. It's not a nice to have anymore. It's a need to have. And being able to consider the cost of compliance versus non-compliance. The cost of non-compliance is not worth it.
I think that is a spot on analysis. Again, Donna, it's a tough thing for consumers. It's honestly, as we're watching it, and Jawan, I suspect without attribution to any company, you would say it's true for companies too. I mean, we're in the middle of dealing and helping companies try to help. As Chris covered at the beginning, we're releasing technical solutions to help solve the issue on the front end and the back end and the client side. But it's a non-trivial exercise at this point to just figure out exactly what you're going to do if you're, a company trying to tackle it. One item that I might put up, because, so much So many of our community, as you know, have been in the privacy realm, but we're getting a huge number of digital marketing leaders coming to Spokes because of the need to tackle this issue. And Donna, I know we prepared this, but we thought for so many of our attendees, we could put up at least a few critical questions that would help spur a conversation between your privacy leadership and your marketing. Mm-hmm. By the way, I'm going to put one point up at the end, and I'll throw it out to both of you. In the US, we're really regulating privacy on a sectoral basis still. Mm-hmm. We don't have the sort of comprehensive law that Europe does. So when you look at the user experience in Europe, it's opt-in, and you have to have a basis to process data. And the result is almost every user experience starts with and is interrupted by a pop-up of some kind. You see that. And when you look at the US side, by the way, the pop-up experience, we've all heard from the user experience, from regulators, from consumers, from data subjects. We heard it a lot from the UK recently, talking about how it's really, really a disruptive experience for consumers and data subjects. You can see California, Colorado, Virginia, and others starting to push against a pop-up, something that is easier, less interruptive for the consumer experience. But there's such a hard balance between giving notice at the time and an opt-out regime and how you actually effectuate these rights. So we're trying to balance it at Wirewheel. I know you all are too. But I am, at the end, I'm interested, if you don't mind me asking you, just so you can think about it, should our listeners think about digital ad tech and MarTech as a regulated industry now in the US, just like you would for certain other areas? So I'll come back to that. When we're covering this with our folks who are coming to Spokes and part of the community, one of the things we noticed is that if a privacy leader speaks with the marketing or digital marketing lead, and you say, are you sharing or are you selling data? Most brands would say, of course we're not. We don't sell our customer data. We don't sell our prospect records. That would be damaging to our brand. And so these questions are meant to have a broader conversation. For example, asking your marketing team, are you using any scripts, tags, or pixels to improve how our ads might perform, when they see them and how they're presented? Are you using any kind of technology or platforms or otherwise that are sharing personal data to measure the performance of the ads? And by the way, those of you that are in the marketing side watching today, it is actually quite difficult to measure the performance of an ad without sharing some personal information in the course of doing so, just because of the nature of the way measurement works. And third, are you using any technology to cap the frequency capping of when an ad is shown? These kinds of questions can be key, in our view, to enabling a really strong conversation between marketing leaders and privacy folks around the technology piece. So I'm going to ask two questions. First is, Jawan, for you, as you're helping and counseling companies around the remediation or fixing things, this sort of ad tech, MarTech angle and the technical items, did we kind of cover most of the items that are coming up there, or are you seeing other items? And for both of you, if you prefer to answer first, should we think of digital marketing and ad tech as perhaps a regulated industry now in the US with California law coming online? I'll turn it over to both of you.
I'll start. The answer is yes. So ad tech, MarTech, use of targeted advertising by businesses is now regulated 100%. Starting from California back in 2020, and as I said, the enforcement has already begun. There are hundreds of companies that received these letters and it's going to continue. And the staff and the size and the budget of the California AG investigations are, I would like to say, rivaling FTC. So, if you were looking at kind of FTC enforcement and kind of pegging your compliance, North Star on the FTC, it is absolutely helpful to take a look at what the California AG is doing as well, because it could be, as Donna said, just as significant, maybe sometimes even more burdensome to have a compliance action initiated by a California state AG. I want to say, I'm seeing some questions here in the chat. I'd like to think of, if for those of you that are calling in today, there are the buyers of these ad tech services, the sellers of these ad tech services, like the ad tech community, and then there are the builders. So I'll put companies like LinkedIn, Facebook, et cetera, as the builders. So there are the tech platforms, and then the sellers are the widgets, right? The myriads, thousands, millions of ad tech and marketing affiliates that are selling these services. And then there are brands like Sephora that are the buyers of these services. And what we have learned as part of this number of investigations that we have handled at the California AG and at the FTC and globally outside of US is that all three of those buckets are receiving regulatory inquiries, right? It's not just for the ad tech community to shoulder the compliance burdens. It's not just for the builders, the platforms like LinkedIn and Facebook to have these controls and to have these frameworks in mind, but also the buyers too. So I think that was the thing maybe that was surprising, with Sephora as a brand, the buyer of these services, to be getting an enforcement action. I think we have seen enforcement action for all three of those buckets. So I think what, Donna said a couple of really fantastic points. What it's generating hopefully from the Sephora settlement becoming live and really kind of a spelling out of what the AG expects in terms of compliance. Hopefully if you do one thing out of the webinar, hopefully, are those three questions, Justin, that you put out, is that if you're an attorney, if you're head of compliance, if you're head of privacy, if you're head of risk, really, at your company, you should be having that conversation, calling up the head of marketing at each of your organizations and asking those three questions. I love it because those questions are practical and it's technical and it's not based on the law. If the answer to any of those questions are yes, then here's a 4-part legal test that you want to do a quick follow-up on. 1, if they say yes to any of those, technical marketing related questions, which is not meant to be for a lawyer, here is what a legal analysis looks like. 1, personal information. The definition of personal information has completely changed. So if you have not re-examined with organizations like the BBB, how to mature your privacy program in the last 2 years, completely changed. So 1, personal information. Is personal information involved? That's a legal analysis. 2nd, is a third party involved? That's a legal analysis. Third party is a defined term in the CCPA, in all of these laws, in GDPR, et cetera. So, and third party is not what you might think. So have a legal analysis on whether a third party is involved in either buying or selling or building these services. 3, is there some kind of a benefit? That also has changed. As Justin, you said, most companies are not selling, right, for money, spreadsheets full of personal data. Most companies would have said back in 2019, we don't sell. That definition, what is a benefit, has completely changed. Again, it's a legal analysis. It's not analysis that we do lightly, right? So engage outside counsel, engage your in-house counsel to have that analysis of, is there a sale occurring under this law, which is a very specifically defined and complicated analysis. 4th is, do you have a contract? And this is probably the easiest thing for you to check. Do you have a written contract for these things? Whether you are engaging with a tech platform, the builders of the world, whether you're engaging with a marketing affiliate or these ad tech services, do you have a service contract? Does it have the service provider prohibitions? That's the easiest way that I have seen our clients fail. So you might not have the best data mapping exercise. You might not have the benefit of BBB or the wild will, engaging with you on all the technical controls, but do you have the right contract in place? You might have all of that analysis done, but if you don't have the right contract with these third parties who are providing these ad tech services, that's where you fail. And it's the easiest, I want to say, for the regulators to say you're not You're not engaging with third parties as a service provider, and therefore you are selling. So I want that to sink in, because even if you think you are engaging with these third parties and their service providers and it's not a sale, the regulator is going to say, show me the contract that has the right provisions. And if you don't, you are selling and the consumers have the right to opt out. That was probably one of the biggest surprising things that we learned.
Joanne, we should put together a supplement with your 4 key items legally, because it goes really well, honestly, with the 3 technical issues. And I think it would be helpful to all of the viewers here. So maybe that's something we could consider and figure out how we could get it out to folks. That was phenomenal. Donna, if I may, over to you. Do you have?
Yeah, no, absolutely. I mean, I 100% agree with you on, especially with regards to paying attention to third parties. And I think there's a little bit of pulling back the layers on third party, right? Because we use that kind of as a generic term, but under California, we have contractors, you have service providers, you have third parties. They all do different things and they're all building on top of each other. So to your question, your original question about whether, these industries, MarTech and digital tech, are they now regulated? Yes, absolutely. And I think it's because of all these different entities who play a part in providing services to the first party company, right? It becomes more and more complex because you have more and more entities who are doing more, who are touching the data. So it just becomes, I think, extremely challenging. This is one of the challenges in complying with the law, is really figuring out who's doing what and where they're handing things off, right? So if you have a contractor who may use their own algorithms to handle or target optimization, you may have a service provider who processes that for you. You may have a third party who then layers their own data on top of all of that. How do you figure all this out? It's a lot.
There's no doubt it's a lot. And I wanted to go start answering some questions because, of course, Donna and Joanne, we're going to run out of time. I'm going to show one thing before we jump in, because honestly, this comes up a lot. And the question is, what is the global privacy control? Like, how does it actually work? So I'm going to share my screen just so we can show this. Obviously, for folks attending, we normally do demos on a company by company basis, and our team has set up this demo site, wirewheel.io/spokes/demo. And you can, and our team will actually walk through. They'll do a scan with you on your site, and they'll show you some of the scripts, tags, and pixels that are firing and exactly where they're going. And it's usually an interesting discussion for folks. Because
so sorry, I just want to interrupt really quickly. And with the 3 of us have talked about this, is I think we need to be really clear about the fact that we may have all interpreted CCPA that GPC was not required. We now know after Sephora, it is required.
Exactly. And by the way, Donna, to your point, this is like the easiest enforcement case you've ever seen. Right. So because you can literally see it right on the website. You can see, our team will do a scan for you. Just register for it. They'll sit down with you. They'll show you exactly what's going on. But you can see the scripts and tags firing. And then you can see very clearly if the company has a GPC collector. So just so people have seen it, our product, this is a version of a GPC signal detection banner, okay? And there are different legal opinions, in my view. We don't give that view, but there's different legal opinions on whether you should actually display a signal collector. Some of the guidance in CPRA strongly suggests that you should, and I'll be curious to see whether that becomes a requirement here. Joanne, maybe you and Donna can hop in on that. But just so folks can see it, in this version of our product demo, we're actually collecting the opt-outs via what legal folks call probabilistic IDs. In other words, we haven't had anybody log in, and what marketers would call anonymous. Marketing folks call it anonymous. I think privacy folks tend to worry about that language. But for everybody, one thing I thought was interesting is, in my view, one of the easiest platforms or browsers to configure global privacy control, and this isn't totally easy, to be honest, is Firefox. because most of the major browsers, you have to actually download a plugin, and the plugins aren't super easy to use in my view. But here, if you go to Firefox, you type in about config, the first thing that comes up is proceed with caution. Donna, I mean, you and Jawan, this is not super easy for a consumer. Like 90% of consumers aren't going to, quote, accept the risk and continue just to configure whether or not they want to drop the opt-out under GPC. Okay, so this is an example. But then in order to get to it, once you get to about config, you have to go and type a global privacy. And now this is how you set it. Okay. So what happens is if the consumer sets an opt-out in the browser, this is Firefox, then our technology, and you can't see a wrapper here, but assume there's a wrapper on the client side for the scripts, tags, and pixels, it'll recognize the opt-out signal and it'll opt the human being out. This is an example of our ability to kind of take opt-outs from each of these kinds of sessions as people go from website to website. And that is an example of the global privacy control. Now, of course, you have to not only take that opt-out in a touchless way, you not only have to manage the things that are going on client side. And again, this is an area where we could talk about it in the future, but there's often marketing going on from the marketing team outside of the website. So you have to have the right technology to make sure your marketing team is aware. So there's a fair amount to it. But for those of you who asked, that is an example of what the global privacy control is. With that, I thought I'd jump into a number of the questions that have come up. I'm just going to start jumping in on them, but Donna, Jawan, if there's one that you would like to answer, please, please jump in. The first one I saw is, what about companies like LinkedIn and Facebook who are actually have the business model selling ads targeting consumers according to a personal profile? Maybe the question would be, where is the opt-out and how is that opt-out supposed to be taken? This is an interesting one. I'll turn it over to Donna. Maybe I have you go first and Jawan.
Yeah, right? I'm thinking about my experience and on the platform, and I'm not sure I even have an answer as to how you would navigate that. I mean, what we have talked about is finding a way to connect the dots with regards to content and disclosure and opting out, right? Instead of having this universal when you first log on opt out, should it be connected to the actual activity that you're engaging in, right? Maybe that connects the dots better for the user. But for LinkedIn and Facebook, I'm just not sure. And it's a very good point, right? I mean, LinkedIn is capitalizing on your profile to target specific things to you. And we all know that as users of LinkedIn. Do we want to shut that off? I mean, what does that do to the LinkedIn platform? What does that do to your user experience? I agree that I'm not sure there's actually a way to do that. Does it defeat the purpose of what LinkedIn is supposed to be providing in general? I don't know. I haven't investigated that.
Jawan, do you have a reaction to the question?
Yeah,
a
couple of things, just reacting to both of you, just because I think the key points were made, and I've definitely seen each of the points that you have made show up in a specific AG investigations. First of all, I think I talked a little bit about the buyers and the sellers and the builders. And so whether you are buying these services or you're selling these services or you're building them, you have a different and separate set of obligations. So the first are each of those, whether you are buying or selling or building, are you specifically complying with and keeping track of this evolving landscape that is now ad tech regs, right? So are you, one, doing your due diligence and doing the right thing in terms of complying with them? And from a consumer's perspective, I think what you are hearing from the press release, spoken from the AG, Vanta, right? If you're looking at the video of the recorded press release, you're right, Justin. I think Donna touched on this. From a consumer perspective, I think the regulators are expecting this to be an easy experience. How many of the people know about config, right? How many have even heard about global privacy control? I'll tell you, back in 2019, almost all of the clients that we were working with, they were doing the legal analysis. Is there a sale? Do we put the do not sell disclosure on the website? Everyone was just really hesitant, right? Everyone was saying, well, we don't sell. And even if we do sell, I'm not sure that we want to put this up. So I'm just going to wait. I'm going to wait and see how the industry plays out. I'll tell you the experience from having done this switch in positions, I want to say, that happened prior to 2020 going live. And then since then, as a result of some of these investigations, a number of the companies that we worked with switched, right? Which was the case for Sephora. I think, Justin, you had said this was an easy enforcement in terms of how you can just see how easy it is for the California agency to investigate this part of the law. It is publicly available. It's on the website. It's very easy to see if you're complying with this part of the law. And then when you get the notice of violation, it draws all of the other issues, as I said. It's never a single issue. It's going to bring in all of the other issues in terms of the many parts of the CCPA. So I've heard, following the Sephora announcement, there were a number of, industry thought leadership webinars and law firms talking about it. And they will say, well, it was so easy to put up a do not sell link. It was so easy to respond to GPC. Why didn't you? And I like to joke that it hurts my feelings when I read those comments, because it's not so easy, right? Getting to that change in position, because when Sephora received the letter, they were not advised by us. I have permission to say this from the client. It was advised by a different client, different law firm. And the position that they took at that time was that it does not sell. And I just mentioned how complex that analysis is, right? So I don't take that responsibility lightly. Through the course of the investigation, over the course of a year, and very significant investment by Sephora, they decided to change the position and to comply with do not sell and GPC. Now, if you're looking at how many people actually use this, yes, the number is low, right? A lot of people have changed from saying I don't sell to sell. And if you look at the number of opt-outs, I think it's really dependent on the industry. Some of the clients that went forward and saying, okay, we got to the legal analysis and conclusion that we sell, and we're going to put up the opt-out. We have clients that received 2 in the last year. I have other clients that are receiving thousands every day, right? So in terms of how the consumer is using this tool to express their consent or their desires and how the data is used, it's very different depending on the industry that you're in. I think that is also an indicator of where you are in this consumer space. But I think the same thing is going to happen with GPC. I don't think a lot of people are using GPC currently. But the way that GPC works, it's, as Justin, you said, a lot of it is anonymous, right? You don't have a way of tying the consumer who has the GPC signal on each of these browsers to the identified user, let's say a logged in user to a Sephora account. So I think that linkage of the anonymous user versus a known user that has an account with your, let's say, an e-commerce site, for example, that's the linkage that companies like Wild Will is helping to do. And that's why I think a lot of our companies, our clients are asking for those kinds of tech solutions. I saw one of the comments, it says it's a team sport. Absolutely. You can't do this just with outside counsel. You can't just do this with industry regulation advice from the BBB. You need a tech platform like Wild Will. You need counsel that's going to tell you what to do, but you also need to know how to do it. And it is absolutely a team sport.
Yeah, Jawan, I totally agree with you. And that's why I think maybe we could come out with a little bit more. It's the legal and the tech and the policy. You have to have kind of a perspective of it. A number of folks have asked that we repost this. So we wanted to put these up for you. We also have a version of this. That's the 3 critical questions the digital marketer should be answering for asking the privacy team member. I'll have our team share that as well. And part of the reason we rebuilt the platform and released it earlier this year as a second generation is you can tell very, very quickly cookie tools by themselves, like just that client-side thing, they cannot solve fully this problem. You have to think both client side and server side. You have to think about the data layer that sits client side. And it's been eye-opening as we've gone in and worked with companies, often with legal teams. where we just do a scan and we show where the data is going, you open eyes, and it's like helpful to the team to actually work together in this way. We are unfortunately out of time, as sad as it is, because there are a ton of them. So what our team's going to do is we're going to capture these questions that have come in today, and we will send follow-ups, and Jawan and Donna, if you don't mind, our team will reach out to you so that we can supplement. So if you have any other questions for our panelists, please post them. We will capture them, and you will actually receive something back from us that actually answers the question. And if you would like us to work with you on a more specific basis so that we can show what's going on technically, or if you need legal help, obviously, I'm sure, Jawan, you would be open to that, I assume, as we go. And Donna, you've been at the center of so many of these issues. I think we're all very grateful for the role that BBB is serving here. So if I may, thank you both for the fantastic coverage of a very difficult set of issues. And Jawan, Donna, thank you for participating on behalf of the entire Spokes community on this session today. I hope you'll both join us again as we cover these issues.